what did the Supreme Court just say about reverse discrimination claims? And what does that even mean? Let's break down their new decision. So in Ames versus Ohio Department of Youth Services, the Supreme Court decided unanimously about this very issue. Now, in this case, Marlene Ames worked for an Ohio government agency, and she applied for promotion. Now, she didn't get the promotion, but also she was demoted from her current manager position. Now, notably, relevant to the lawsuit, Marlene Ames is straight, but both the person that got the promotion and the person who replaced her as manager, they were both either gay or lesbian. And so Marlene Ames sued under Title VII, which is a federal, in the U.S., anti-discrimination law. And she sued saying this decision was made, at least in part, because she's straight in favor of those who are gay or lesbian. Now, this is what people sometimes call reverse discrimination. And a lot of times people say, no, discrimination is discrimination. A lot of talk about that term. But what people often mean when they say that is when someone who's in a majority, like who's straight, is discriminated against in favor of those who are in a minority, such as gay or lesbian. People also have this come up in the race context, sometimes gender, if there's a majority male population and a male sues being discriminated against for a female. So anyway, this is what people often mean when they say reverse discrimination. Now, when you bring this type of lawsuit, any type of anti-discrimination lawsuit, there's a whole back and forth in court. But the first thing an employee generally has to bring, or a candidate, is to show basic things like I either applied for this job or I had this job, I applied for promotion, some sort of employment action. I didn't get it, or I got my pay docked, or I had some sort of thing happen to me, and I'm in this protected class. That's one of the categories of Title VII, like gender, race, sexual orientation, those type of things that are covered. So I'm protected. And other people who are in a different protected class than me, they were treated better. So in this, Marlene Ames would have fit that. She is saying, I'm straight, I applied for promotion, I didn't get the promotion, I got demoted, and two people were treated more favorably, they got it, and they were gay or lesbian. And so normally she would have at least fit that. And it's normally a pretty easy test to meet. The harder thing for most plaintiffs in employment cases in the U.S. is proving that it was because of discrimination. Often the business or employer has the opportunity to come back and say, no, this is why we made the decision. In the U.S., employers often win those legal arguments. But even at that first step, the one that's generally pretty easy to meet, some different circuits of the U.S. and federal courts are broken up into circuits. Some circuits have had this test that in addition, in a reverse discrimination claim, in addition to showing these things, like I'm an employee, I applied for these things, XYZ, you also have to show something called a background circumstances test, showing that that employer would be one of the unusual employers that would discriminate against a majority in favor of the minority. So in this case, would have to show something extra right at the outset, that this government agency would intentionally discriminate against a straight person in favor of LGBTQ plus employees. And so what does that look like? Well, in the Sixth Circuit, which is where this case was, and there's some other circuits, that can be shown by things like showing that the decision maker was LGBTQ plus. Like sometimes that can fit it, or statistical evidence of, hey, straight people haven't gotten these promotions, things. So whether the person involved is part of the minority group or statistical evidence, that's what that's looked like. But when the Supreme Court looked at this, they unanimously decided, and notably, the decision was by Ketanji Brown Jackson, Justice Jackson, who tends to side with the more liberal, or you may think like employee-friendly justices. But all of the justices in this case agreed, and there's some sort of like additional notes by other justices, but here they all agreed that this background circumstances at the outset is illegal. That under Title VII, whether you're suing because you're in a minority group and alleging discrimination on behalf of that, or if you're in that majority group, like the plaintiff Ames saying that she's straight, that in both of those circumstances, that it's not legal to have to require background circumstances. So no longer would a plaintiff claiming these have to show things like the decision maker was part of this group, or show statistical evidence and things like that. And so overall, candidly, the decision's not that surprising to a lot of legal experts that had looked at it. And there had been a circuit split, so it wasn't just this case. A lot of the different federal courts had held this background circumstances case of that plaintiffs at the outset have to show, there's some reason that an employer would be discriminating against a majority. But because this isn't at all in Title VII, and this adds another requirement that's not part of that law, a lot of people expected to get this struck down. So what this means is that anyone bringing a discrimination claim under Title VII has to now have the same claim, whether they're in the majority or minority. Still, it can be hard to bring a successful claim because when the employer comes back and they have the opportunity to do that, to show why the decision was made, courts often will give deference or leeway to employers to say, okay, ultimately this is a business decision. And there's all sorts of cases, and anybody should always get their own legal advice. But often that's where plaintiffs in these cases fail, whether they're in the majority or minority, because they don't have proof of discrimination or the employer has a reason, and then the employer ends up winning. And so altogether, this does make it, though, easier for those plaintiffs or those employees or candidates in those reverse discrimination claims to bring those. And it's getting a lot of attention in the media, this decision. So that's what it means. And that's overall what reverse discrimination means. So that's the breakdown.